The number you have reached, 911, has been changed to a non-published number.
Good day, ladies and gentlemen. Welcome back to CLTV. Sorry there was no post earlier this week, but I kind of got wrapped up in some jury stuff. Okay, well, moving on. Today is basically the Fave 5 day. I list my favorite 5 posts from the last week from the Criminal Law Web. Before we get there, we're going to do CLTV Sports News. And yes, ladies and gentlemen, I told you, at least I did in the blog, those of you who follow it, that I was going to become insufferable if my schools keep winning. Well, ladies and gentlemen, my schools are keep winning. So I'm on the verge of becoming insufferable. Last week, on Friday, Center College, which was ranked 14th in the nation in Division III basketball, was playing Millsaps College, which is ranked 18th in the nation in Division III basketball at Center. It was a big game, and doggone it if Millsaps didn't beat on Center for most all the game until the last 46 seconds when, with a flurry of 2 3-pointers and then 1 2-point layup and fouls, which Millsap made all his foul shots, Center brought it to within 3 points, and then this happened.
6 seconds. This side he double teamed up top. Brent. 3 seconds. 2 seconds. Puts it up. God, with 3/10 of a second. Thomas Brent from 28. Are you kidding me? Unbelievable. All night for Thomas Brent. 23 points.
After that, Center went on to win in overtime by 10 points with 2 more 3-point shots by that same player who had done all 3 of them in the last 46 seconds of the game. So Center then moved on to become number 11 in the nation. And I want to thank D3 Hoops, which is part of D3Sports.com, D3Hoops.com, which is covering all Division III basketball and was kind enough to go cover this at Center. Center doesn't cover its basketball games or football games, doesn't put them out. Live Stats doesn't put them out on the internet through either video, which we've seen a lot of schools have started to do, Division III schools have started to do. I mean, you're getting video that big, but it's video, or audio. Center just doesn't do any of that stuff. And still has put together a really good team last year and this year in basketball. And furthermore, D3Hoops.com had the coach from Center on their Hoopsville show on Sunday night, and they were talking about how things were going and how well Center's doing in the game and everything. It's kind of funny because the coach was talking about how Center's an academic school, and you could tell that the interviewer didn't get what he was saying, you know, because all schools are academic schools, right? You know, you just could tell that the announcer hadn't been sitting in the first day of classes where almost universally professors announce, you get 3 absences from my class, the fourth absence must be excused, otherwise you fail the course, and sports are not an excused absence. And where the school where the last time Center's football team was invited to a bowl, I think this was the 50s, the bowl conflicted with finals, and the professors voted not to allow the team to go to a bowl. So that kind of tells you where academics rank as opposed to sports at Center, which is a wonderful thing when you're planning on becoming a student and go there. You know you're going to get top-notch academics, but then when you're an alumnus or and you want to follow things, it's not exactly the same as follow. You can't go back and go, and Kelly Smith got a 3.8 GPA average the last semester. It just doesn't have the same ring as following the sports does. But Center still puts together good teams. I don't know how they manage to do it. I guess some smart people want to play sports. And beyond that, beyond center, there's my high school, Bryan Station, still going on. Hasn't lost a game since the first game of the season, which is exactly like center. Center hadn't lost a game since the first game of the season either. My high school hasn't lost a game since the first game of the season, and played Mason County that game, which is, for those of you who are from Kentucky, know is always one of the top 2, 3, 4, 5 schools in the country, state, Commonwealth of Kentucky. Bryan Station's ranked number 1, still driving on. No real guarantees there at the end of the season. The last game is against Mason County. And of course, Bryan Station plays the Lexington teams, which are good homegrown teams. And to get out of I think the region, they have to play Lexington Catholic, which is, anybody who watched the season where they followed Lexington Catholic to win its first state championship knows Catholic recruits like crazy. I think one of my favorite points in watching the season was when a player from the opposing team walked up to the Lexington Catholic coach and said, "Great team you bought for yourself there, coach," and walked on. Bryan Station, by the way, is fully homegrown with a great coach. It's amazing how well this team has come along, considering that last year the idiots in the administration tried to fire the coach. Who knows why? Because last year they ended up somewhere in, I think they ended up being ranked 6th or 7th or something like that, which wasn't enough to get them out of the region, where there were, I think, 3 other teams ranked ahead of them. But they were a really good team last year. Let's move on to the Fave 5. My favorite 5 postings of the last week. We're going to start out with Objection. An Objection has a posting about a soldier who got a DUI from a civilian police officer, and who calls up to his office, speaks to one of his assistants or secretaries, and says, gives her the pity story about, this, that, and the other thing. And, they thinking, well, maybe we'll do something for this guy. Until they see his MySpace page, where after having talked to the assistant, he brags about how he's going to get away with it. And really pretty obnoxious about it. Lesson here, folks, is that your MySpace page is not private. I have one. I'm here to tell you, you're all welcome to go look at it any time. I think the most embarrassing thing I've ever had on there was probably, for a while there, I had posted I'm a Marvel, I'm a DC videos, which were funny, but, well, I am a little bit old for that. But, and I know that I've been in various jurisdictions where the police comb through MySpace and Facebook to see what's going on, because people are just amazingly honest. They just don't seem to realize that other people can read these things. Then we go on to Underdog, and Underdog's talking about international extraditions. He's been hired for one, and how it should be fought more than local, interstate, I should say, extraditions, because there's actually more to fight than an interstate extradition, because, well, as we all know, interstate, as long as you are the person, you're going to get extradited. Not necessarily the same thing in extraditions to other countries, where there could be political reasons for that. And he actually talks about, and seems fairly surprised, that a prosecutor decided to drop this extradition because, well, the guy had been tried in his absence, and punishment set in his absence, and there wasn't going to be a new trial if he went back. He was just going to go back and get it. And that denial of due process was enough that the prosecutor dropped it and let him go without being extradited back to his country. Next we get to white collar crime, where white collar crime is talking about, is asking a question like, something along the lines of, if you are conflicted, say you've represented some co-defendant for a very short period of time, and you try to represent the second person, along with some other attorneys, the second co-defendant with some other attorneys, and the judge says, no, you can't represent that person. Can you then stay on board, not actually giving legal advice about the case, but giving advice to the other attorneys, who apparently must be from another jurisdiction, about procedural happenings, the way things work in the courts in your jurisdiction. White collar crime prof seems dubious about this, and I gotta admit I am too. I just don't see that one working out, because procedure and the actual facts get intertwined in almost every case. And if they're intertwined, you're going to be talking about facts that you possibly have information from representing the co-defendant. And that's clearly the conflict. So next we get to Norm Pattis, and he's discussing insanity and insanity pleas and the tactics of an trial during an insanity plea. And he's upset, or seems to be upset, because a case, I guess one that he was trying, went forward, and before trial the defense had the defendant checked out by an expert. The expert said the defendant was insane at the time of the offense, and the prosecutor did not have the defendant checked out. Apparently, even if he had the opportunity, I don't know what the laws are in the particular state. I would assume that most states require that he be allowed to have the opportunity to do that if there's an insanity defense. But anyway, the prosecutor didn't do it, and in this case, defense puts on its insanity defense. Its expert comes up and says, "Yeah, he was gone," and the prosecutor stands up and, while sniping at the basic stuff like, well, could he drive for 3 hours and be, totally insane? Could he formulate a plan? Could he do X? Could he do Y? Could he do Z? The prosecutor also points out that, you're getting paid $450 an hour, aren't you? And either implies or maybe says directly in his closing that this is a hired gun. And of course, the jury goes back in the back, and apparently they bought the prosecutor's side of that rather than defense counsel's, and decided not to pay attention to what this guy said and found the guy guilty. I don't know that I agree that, as Norm says, that there should be a requirement that the prosecutor have them investigated or have them checked out by a psychiatrist if the defense attorney has said he's going to use that defense and provided a report saying that he was insane. The defendant was insane at the time of offense. Maybe the judge, and I can remember as doing court-appointed work, I several times asked the judge for an expert to check him out. It was almost always the government's expert, which, seemed problematic, but he's supposed to be impartial. And judge after judge after judge, I can't remember a single judge that turned me down when I walked up and said, "Look, my client's back here banging his head against the wall saying that the space aliens are coming, and the only hope that he has is to get home and let the dragons out of the basement so they can kill the space aliens." I come out and say something like that to the judge, and my client gets evaluated. At least that's the way it worked in Virginia, in very conservative jurisdictions, which wouldn't give me experts for much of nothing else, or private investigators or anything else. They would give me the mental evaluation pretty much every time for competency and for insanity at time of offense. That might be the way to handle what he's talking about. I don't think you should really force the prosecutor, who might very well believe that this insanity thing is a bunch of garbage, and very well believe, whether it's true or not, that $450 an hour expert is a hired gun, and he is going to say anything that the defense counsel wants him to say. And then, I don't think the prosecutor should be forced to take the step of developing evidence for the other side. At least not in that case. Now, moving on to the last point, we get simple justice. And simple justice is going over a case where, in the federal courts, a defendant told his defendant or potential defendant told his attorneys certain facts. His attorneys represented these certain facts to the prosecutors, and the facts turned out to be not true, apparently. So, therefore, the defense attorneys are being forced off the case because they would be witness to the obstruction charges. Holy cow! Man, that's, I I don't know how many, maybe 40% of my cases as a defense attorney, that serious cases, that would have ended up with me testifying against my client and being off the case. And a whole bunch of the defense attorneys come talk to me, the same situation. I could say, jury found that these facts were different, and I'm going to make you off the case, or not even before a jury finds those facts are different, because that's when the feds do this stuff a lot of times. I'm just going to say, we think we can prove the facts are different, and your client lied to you, and you lied to me in his behalf. Well, and get them off the case, and have them as witnesses against their own clients. And what do you say? Do I hear you say privilege? No. The judge said that privilege doesn't count because we get the crime fraud exception here. You can't. There's no privilege when your client tells you something that's going to be a fraud on the court, or a fraud on the court, or that he's going to do a future breaking of the law. I'm not sure in negotiations with the prosecutor that's a fraud on the court, and I'm not sure that he is told. I don't think he's told his attorneys when he lied to them, assuming that actually happened, that he's going to break the law in the future. So I don't think that that exception really applies. Now, I don't know the niceties of all the federal law on this, and the federal law on this not having. Let me clear something out. When I said that I could have gotten in trouble, and my client and my defense attorneys come talk to me now could get in trouble. We can't really in Virginia because we have the exculpatory no doctrine, which the feds have just gotten rid of, and which is why you see the feds not bothering to actually arrest people and prosecute them on the things that they think they did, but getting them on the much easier charge of having told them a lie. We can't do that in Virginia because of the exculpatory no doctrine. If somebody lies about something they did, well then that's not really obstruction. At least not under our law. But it is in the feds, and this is just kind of strange. I don't know. I don't practice in New York, never have. I don't practice in Florida, never have. I have for years heard these rumors about how federal prosecutors in Florida and New York, if the defense attorney gets too good, he suddenly ends up having charges of his own or being bumped off. They find some way to get him off the case, try turning on his own clients like this. I don't know how prevalent this is, if it's really true. I know that, like I said, there's been rumors for years about this stuff. I got to say that, you can't get much more rabid than Virginia, at least the Eastern District of Virginia was, as far as prosecutors go, and I didn't see them doing that to anybody. So, I don't think this is a prosecutorial thing in all the federal system. But those of you who are in New York and Florida probably have a better grasp on this than I do, and look forward to your comments on it. Well, ladies and gentlemen, that's my 5 for this week. And you may agree, disagree. You're welcome to post your own 5 that you think were better. But that's all I've got time for now, and I return you now to your regularly scheduled blog reading.